Hello, this is Ron Clymer again. This is number 7. This is number 7 in the reading of the comments from the North Carolina Real Estate Commission. I got to trust funds last time and I stopped it, so we're going to start with that. And we are on page 18 in the free download from the North Carolina Real Estate Commission .gov, that's ncrec.gov, and I'm at the bottom of page 18 in the second column, handling trust funds. This section addresses those aspects of handling trust funds that are taught in the real estate broker pre-license course and tested on the real estate license examination for entry-level brokers. All brokers are encouraged to take the basic trust account course for a fuller treatment of this subject. The basic trust account course schedule is available on the Commission's website at www.ncrec.gov. Definition of trust money. In the context of real estate transactions, trust money is most easily defined as money belonging to others received by a real estate broker who is acting as an agent in a real estate transaction. It is also any money held by a licensee who acts as a temporary custodian of funds belonging to another. Such money must be held in trust even if the circumstances are only collateral to the licensee's role as an agent in a real estate related matter. A listing agent receives money from his out-of-town sellers for yard maintenance while the property is being marketed. The most common example of trust money are earnest money deposits, down payments, tenant security deposits, rents, homeowner association dues and assessments, and money received from final settlements. In the case of resort and other short-term rentals, trust money also include advance reservation deposits, state and local sales taxes on the gross receipts from such rentals, trust or escrow of funds, GS 93A. One of the most basic tenets of broker accountability when handling trust money is it must be deposited into a trust or escrow account as described below. A trust account or escrow account, the terms are synonymous for commission purposes, is simply a bank account into which trust money, and only trust money, is deposited. The three primary features of a trust account are that it is separate, containing only money belonging to others, custodial, meaning only the broker or the broker's designated employee have access to the account, but no one has funds in the account has access, and it's available on demand. That is, the funds may be withdrawn at any time with no prior notice. The type and location of trust accounts. A broker's trust account or trust account must be a demand deposit account in a federally insured depository institution, lawfully doing business in North Carolina, that agrees to make the account's records available for inspection by the Commission representing GS 93A. This is for the purpose of holding most trust money. The bank can be located outside North Carolina if the foregoing conditions are met. However, there are two notable exceptions, namely, North Carolina residential landlord-tenant laws still require that a residential tenant security deposit be deposited in a trust account with a licensed and insured bank or savings institution located in the state of North Carolina. 2. License laws regulating timeshare sales also require the developer and timeshare salesperson, who must have broker licenses, to immediately deposit all payments received in connection with the timeshare sale into a trust account in an insured bank or savings and loan association in North Carolina. And such payments must remain in the escrow account during the purchaser's 10-day cancellation period. Where two laws conflict, generally the most restrictive law controls. Thus, it would appear that a broker may have his or her general brokerage trust account in any depository institution that otherwise satisfies the four components identified above, except for trust accounts containing residential tenant security deposit from properties located in North Carolina, or initial payments related to a North Carolina timeshare sales. The latter two trust accounts should be opened in an insured bank or savings and loan physically located in North Carolina, unless other statutorily permitted financial arrangements are made to secure these money. Designation of trust accounts and FDIC insurance. A broker in charge who must maintain a trust account must ensure that the bank properly designates the account and that the word trust account or escrow account appear on all signature cards, bank statements, deposit tickets, and checks. Even though the escrow account typically is in the name of the company or broker, so long as the broker properly designates the account as a trust or escrow account and keeps accurate records that identify each owner of the funds and or depositor, buyer, seller, lessor, lessee, the depositor are protected from the funds being frozen or attached if the broker becomes insolvent, incapacitated, dies, or has tax liens, becomes involved in a lawsuit. Failure to properly designate an account titled in the name of the company broker as a trust or escrow account may result in attachment of the account by others to collect a judgment or denial of FDIC insurance coverage as to each individual interest in the account. So long as the account is properly designated as a trust account, all deposits are insured by the Federal Deposit Insurance Corporation, FDIC, up to $250,000 per individual for whom funds are held. Thus, a broker's trust account may contain $500,000 total, but all funds are fully insured so long as no one individual interest in the account exceeds $250,000. Note, however, that an individual still may be underinsured if the individual maintains accounts in his or her individual name or at the same financial institution as the broker's trust account. When a trust account is required, a broker must open and maintain a trust account when the broker of any affiliated license takes possession of trust money. A broker who is inactive or otherwise not using his or her real estate license is not required to open and maintain a trust account because he should not be engaged in brokerage nor receiving monies belonging to others. Similarly, if an active practicing broker does not collect or otherwise handle the funds of others, no trust account is required. Number of trust accounts. Except for brokers who are managing homeowner property, number of trust accounts. Except for brokers who are managing homeowner or property owner association funds, a broker holding trust money is only required to have one trust account. All earnest money deposits, tenant security deposits, rents, and other trust monies may be deposited into this one common trust account. However, brokers who are active in both sales and property managers often find it helpful to use more than one trust account. For example, they may wish to keep a general sales trust account for earnest money deposits, settlement proceeds, etc., and a rental trust account for tenant security deposits, rents, and related receipts. Although it's not required, many brokers involved in property management and leasing elect to maintain an additional security deposit trust account to keep tenant security deposits separate from rents and other related receipts. However, Rule A0118 requires brokers who handle homeowner or property owner association funds to maintain a separate trust account for each property owner, association, or homeowner association they manage. The funds of one homeowners association are not to be commingled with funds from other associations, nor with any general trust monies. The broker must also provide the association with periodic written statements, not less than once each quarter, reporting all monies received, dispersed, and due, but not paid, i.e. delinquent, as well as the balance of funds in the account. Hold on, I have to take a sip. Commingling Prohibited. The basic statutory provision relating to a licensee's handling of the money or property of others states that a broker may not commingle his or her own money or property with the money or property of others. This means that a broker may not maintain funds belonging to others in the same bank accounts that contains his personal or business funds. Funds belonging to others must be held in a trust account, and except as described below regarding bank service charges or trust accounts, a broker may not deposit his or her own funds in that trust account. The prohibition against commingling also means, for example, that a broker who has an ownership interest in property is precluded from depositing monies, earnest money, rent, security deposit, related to that property in his brokerage trust account. Readers are referred to the Commission's trust account guidelines for a more in-depth discussion of how to handle broker-owner funds. Bank service charges on trust accounts. Trust accounts usually are subject to the same service charges as regular checking accounts. Whenever possible, brokers should arrange for the depository bank either to bill the broker for these expenses or charges to the broker's personal or general operating account. However, if such arrangements cannot be made, the Commission will permit a broker to deposit and maintain in his trust account a maximum of $100 of his personal funds for such other amounts as may be required to cover, not avoid, such charges. So if a broker's monthly service charge and other fees typically are $100, then he may deposit up to $200 of his own money to cover these charges. A broker who deposits any of his own money in the trust account to cover bank charges must be careful to properly enter and identify these personal funds in their trust account records. While this technically constitutes commingling, it is permissible commingling to avoid the greater evil of using other people's money to pay these bank charges. Interest-bearing trust account. Both GS 93A and some other rules permit the broker to deposit trust money into an interest-bearing trust account so long as the broker first obtains written authorization for deposit in an interest-bearing trust account from all parties having an interest in the monies being held. Such authorization must specify how and to whom the interest will be paid. If the authorization is contained in an offer, contract, lease, or other transaction instrument, it must be set forth in a conspicuous manner that distinguishes it from other provisions of the instrument. Remember, however, that all trust accounts must be a demand account. So investment of trust monies in any type of security, such as a government bond or fixed-term certificate of deposit, is prohibited. Broker in charge responsible for trust accounts. Rule A00117 requires a broker to maintain complete records showing the deposit, maintenance, and withdrawal of money belonging to the broker's principals or held in escrow in trust for the broker's principals. Paragraph G of that rule also provides that the Commission may inspect trust account records periodically without prior notice whenever the records are pertinent to investigation of a complaint against a licensee. Rule A0110 refines this requirement by specifying that a BIC is responsible for the proper maintenance of a real estate trust account and the records pertaining thereto. Custodian of trust account records other than the broker in charge. While a broker in charge may transfer possession of trust money to a bookkeeper, secretary, or some other clerical employee to record and deposit the funds in the trust account or to maintain trust account records, the broker in charge nonetheless remains responsible for the care and custody of such funds. Brokers in charge could closely and diligently supervise the acts of all persons having access to the trust account, since final accountability for the accuracy and integrity of the account rests with the broker in charge. Access to trust money should be limited and carefully controlled. Disbursement of earnest money. This rule permits a broker in charge to transfer earnest money deposits from his or her trust account to the closing attorney or other settlement agent not more than 10 days prior to the anticipated settlement date. Earnest money may not be dispersed prior to settlement for any other purpose without the written consent of the parties. Thus, earnest money may not be used by the broker to pay for inspection reports or other services on behalf of the buyer prior to settlement without written consent of the seller, and vice versa. Disputed trust funds. Rule A0116 addresses disputed trust funds as follows. In the event of a dispute between buyer and seller or landlord and tenant over the return or forfeiture of any deposit other than a residential tenant security deposit held by a broker shall retain said deposit in a trust or escrow account until the broker has obtained a written release from the parties consenting to its disposition or until disbursement is ordered by a court of competent jurisdiction. This rule also references GA 93A, procedures for depositing disputed funds with the clerk of the court, as well as when one party abandons his or her claim to disputed funds. However, these procedures are beyond the scope of this material and are more important for brokers in charge to know. Handling of trust money. Rule A0116. The general rule is all trust monies received by a licensee must be deposited in the trust account within 3 banking days of receipt. Exception: earnest money received with offers to purchase and tenant security deposits in connection with leases must be deposited in a trust account not later than 3 banking days following acceptance of the offer to purchase or lease agreement, unless the deposit is tendered in cash, in which event it must be deposited within 3 banking days following receipt, even if the contract or lease has not been accepted. In part, this is because cash is immediately available and may be refunded within a day of deposit, unlike checks, which may require a few days to clear. Understanding that a broker may choose to immediately deposit a check received for earnest money deposit or tenant security deposit is not required to wait until contract acceptance unless so instructed by the buyer tenant. Of course, early deposit may cause problems if the offer to purchase or lease is not accepted. If the prospective buyer or tenant understandably wants their deposit to be immediately returned, the date of acceptance must be shown in the purchase or lease agreement to determine when the 3 banking days begin. Receipt of trust money by provisional broker. All trust money received by a provisional broker must be delivered immediately in the provisional broker in charge. In other words, provisional brokers may not retain or hold trust money any longer than absolutely necessary to deliver the trust money to his broker in charge. Similarly, trust monies received by a non-resident limited commercial broker are to be delivered immediately to and held by the resident North Carolina broker with whom the non-resident is affiliated. Brokers in charge should have written policies that clearly state the procedures to be followed when any agent affiliated with the company, whether provisional or non-provisional broker, receives trust money. Handling option money and due diligence fees. Rule A116 states in part, a broker may accept custody of a check or other negotiable instrument made payable to the seller of real property as payment for an option or due diligence fee, but only for the purpose of delivering the instrument to the seller. While the instrument is in the custody of the broker shall, according to the instructions of the buyer, either deliver it to the seller or return it to the buyer. The broker shall safeguard the instrument and shall be responsible for the parties to the instrument for its safe delivery as required by this rule. A broker shall not retain such an instrument for more than 3 business days after the exceptions of the options or other sales contract. The rule is basically self-explanatory. In the rule, custody means possession. Recall that option money or a due diligence fee is paid directly to the seller, to whom the check is written as payee. So it is not appropriate for a broker to deposit these checks into his trust account because the check is not payable to the broker or real estate company, as in the case with earnest money checks. Either the listing agent or the buyer's agent may hold the check or negotiable instrument until negotiations are completed and a contract is formed, at which point the check should be delivered to the seller as soon as possible. If, however, a buyer for some reason gives a broker cash for the option money or due diligence fee, then the broker must immediately deposit the cash in his trust account pending contract formation, as cash must always be deposited into a trust account within 3 banking days of receipt. No exceptions. If a party enters into a contract, then the broker would write a check from the trust account payable to the seller, noting in the memo section in trust account records that if for the option fee or due diligence fee from the buyer. Safeguarding trust money, improper use of trust money. Rule A116. This rule places on every licensee the responsibility to safeguard the money or property of others coming into his or her possession according to the requirements of the license law and commission rules. In addition, it states that a broker shall not convert the money or property of others to his own use, apply such money or property to a purpose other than for which it was intended, or permit or assist any other person in the conversion or misapplication of such money or property. And that is probably a good place to stop. This is Ron Clymer at First Real Estate School in Hendersonville, North Carolina. And we are reading the North Carolina Real Estate Commission's comments on the license law. Now, if this is doing you some good, I sure would appreciate it if you would go down there and click that like button. And if it's doing you a lot of good, you could leave a comment. And if you'd like to share it with your friends on your Facebook page or whatever, do that. Now, also, if you don't know if it's doing you any good or not, when we finish with this, go to www.ncreexam.com and take my 100-question test. Now, if you're not making at least an 80 on that test, don't go waste your $164 taking the real thing. Study some more. Listen to this again. By the way, feel free to listen to this 8 or 10 times. It won't hurt my feelings, and it won't hurt you either. Especially if you're just sitting around watching TV or something, you can watch me read this and have your family join you. That'd be a good idea. I'll see you next time.